All right, guys, this is the last PowerPoint presentation for Task 1. And we're looking at how the Constitution is changed. Now, obviously, in formal ways, can change the Constitution. Judicial review can change the Constitution. But the formal way of changing or amending the Constitution is laid out specifically in Article 5. And if you think about it, it's only been done 27 times. And the framers deliberately made it difficult to amend or change the Constitution. And you have to ask yourself, why is that? Well, I think it's not out of vanity, but certainly the ability to keep the ideas that the founders had in place without a great deal of change kind of demanded that the amendment process be difficult and have purpose. You don't want to do it willy-nilly. We don't like to think that the Constitution, as in in that movie short Universal Absurdity, you need to have the 210, 211th, and 212th amendments to the Constitution. My God, what was 28 through 209? Sounds like you need to have, the way that's done, a constitutional amendment for virtually every human action, which is not something that the founders wanted or thought that we needed. Now, Americans often have, I often have a love-hate relationship with government because after I had that epiphany in 2006 in realizing that the party that I had grown up with no longer represented my views and I felt was a threat to me because they were certainly promoters of big government, was a benchmark in my life, and it's not one that has been replaced. Once I left that party, and like it says here, I did recognize that an active government is needed to protect, guarantee, and advance the individual's opportunity to enjoy liberty. And I thought about that after the attacks on 9/11. I thought about that after Katrina in 2005. I thought about that for any number of modern day subjects that that confront us and create perhaps sometimes dilemmas. So this isn't an easy thing. I do respect the fact that there are parts of government that are needed. I do wish that some parts of government weren't around because I really don't think we're needed. So the question becomes, is the Constitution alive? And that is something that you don't have to write in your notebook, but you have to write as a thought, and it's probably something I'm going to put in Google Classroom as something I would like you to answer. How does Article 1, Section 8, Clause 18, which are what we are known as implied powers, and Article 5, which is the process to change our Constitution, make our Constitution a living document? Well, first and foremost, doesn't implied powers, by not specifically mentioning what those powers are, but implying that they're there based on the fact that the entity that is exercising those powers is the national government. And Article 5, which is a more formal way of changing the Constitution to meet an unmet need, I think it does make the Constitution a living document. It just doesn't get changed formally very often, which I think is actually, again, a good thing. Now, in many of the Constitution, let's look at this. So on the left-hand corner, we have the Constitution and Article 5. And we want to add an amendment. So we go all the way over to the right where it says, let's add an amendment. Now, let's stick to the outside for right now. So we have the box called Let's Have a Convention. And it's called by Congress at the request of 2/3 of state legislatures. The proposed amendment that is passed by the convention must then be ratified by 3/4 of the state legislatures. And this has never been used. And there's a reason for this. Let's say there's an issue. We say issue X. And the states prod Congress into calling a convention, a constitutional convention. And so they meet in a city in a convention hall. And instead of just dealing with problem X, they also decide to take on problem W, Y, and Z. They were not given that exercise to do by the states. But there's always been a thought that the conventions themselves, because they could easily be taken over by interest groups, that those interest groups would not only take care of the problem that they originally met for, but they would also then prod the convention to exercise their judgment and approve amendments for other things. Now that's far-fetched, and I know it's far-fetched, but it is actually a fear that many have, that you would have what's known as a runaway convention, in which the participants decide to tackle other things. It's kind of like what happened with the Constitutional Convention. They're sent there to change the Articles of Confederation, wind up throwing that out, and creating a new constitution. So that's never been tried. It seems to be easy. It's a little bit messy, but it's not as controlled. And lots of groups can, I think, help guide the alternative way. So you add an amendment, you propose the amendment in Congress, it's approved by 2/3 of the House and then 2/3 of the Senate. It is then sent to all 50 state legislatures, and 3/4 of all those state legislatures must vote yes on the proposed amendment within 7 years, unless Congress gives a proposed amendment an extension, or like the last amendment that was added to the Constitution, there was no limit at all. It was written without a limitation, which was why it was passed over 200 years later. So this is the formal way of amending the Constitution. It's pretty easy, but just remember that the only way that we've ever added a Constitution is through the proposed amendment method, through Congress first and then going out to the states. So the formal amendments have expanded liberty. It is in particular true of the civil rights amendments of 13, 14, and 15. It's certainly true of the Bill of Rights, the original 10 amendments. But look at all the other things that have been added: direct election of senators, the right for women to vote, the right of 18-year-olds to vote, succession to the presidency. What one amendment taketh, the other amendment giveth back. And that was, of course, prohibition. So there's lots of things. And of course, the other question is that, and most people don't realize this, but the question that can we change the Constitution without an amendment? Well, yeah, that's an obvious answer. It's yes. If we didn't have an alternative to a formal addition of an amendment to the Constitution, then boy, we would have not grown as a country. We would be perhaps throttled when it came to any sort of change that people wanted to institute. So the Constitution is flexible. It's short, It does not attempt to describe or prescribe every detail, every human action. But it's not static. It's flexible, and we've been able to change the Constitution in a number of ways, which have allowed it to change to meet the needs of future generations. Perhaps not to everybody's satisfaction, but I guess it's kind of taken a middle route, and therefore, where perhaps not everybody is satisfied with it, everybody is satisfied that things have happened that they don't like. Now we know that the Bill of Rights was the big promise that was made to those who were opposed to the ratification of the Constitution. And those are based on a number of rights that were in state constitutions. They weren't copied word for word, but they're very, very similar. The Bill of Rights is very similar to a number of parts of state constitutions. It was an agreement made by the Federalists and the Anti-Federalists in order to pass the Constitution. It protects the civil liberties of individuals in the U.S. And I don't want you to mistake what civil liberties and civil rights are. Civil liberties are what's guaranteed in the Bill of Rights. Civil rights are what amount to policy to level the playing field for individual groups and individuals in the United States. So when you look at this, I think that bottom two sentences are very important. Your freedoms are not absolute. They are limited by the rights of others. So it's a yin and a yang, and therefore you cannot yell fire in a crowded theater. You're able to worship in any manner you are, but if you are hurting others, human sacrifice, things like that, of course you cannot worship in that manner. Now let's go through the amendments. The First Amendment, pretty easy: freedom of religion, press, speech, and assembly, and theoretically giving you also a right to privacy. The right to assembly and freedom of speech, it most likely both limits and protects your freedoms. The limitations are creating the conditions of, let's say, a demonstration in which you're trying to keep people from being hurt. So you allow them to demonstrate, but it may be under very strict protocols. Freedom of speech, you can pretty much say anything, but remember, there are slander and libel laws in place that keep you from going way too far. And of course, if you bully someone online, you can also be charged with things like manslaughter or second-degree murder, or even worse. So the right to assembly and the freedom of speech is not absolute, but it's pretty flexible. The Second Amendment, of course, is the right to bear arms. This amendment guarantees the states the right to keep a militia, and unfortunately, I missed this one, but you kind of know what this amendment is about, and it is basically a well-regulated militia being necessary to the security of a free state. The right of people to keep and bear arms shall not be infringed, and that's a huge battle between especially the left and the right. We can see that the number of respondents wanting a law to ban possession of handguns, wanting a law to ban handguns. This is Gallup. We can see that the number of people who want laws to ban possession of handguns has actually grown smaller as time has went on, and especially has hovered around 30 to 35% since 2000. Then we have to ask the question: does the right to bear arms mean that everyone can carry or own a gun? And when does the right of an individual outweigh the needs of a society? And that's probably that second question is probably the bigger of the two, especially when you have multiple killings occurring at events like in Orlando the school in Connecticut or the theater in Denver. Um, you know, that's an important question. This cartoon says the First Amendment gives you the right to say what you want. The Second Amendment gives me the right to shoot you. That's really out there, but we put these in there, and I know that these people here are probably people who don't want widespread gun usage, but it is what it is. It's kind of an amusing cartoon. Now, the question is, too, do you as an individual have the right to bear arms? And there's been two cases that have had an immense impact on how the Second Amendment is interpreted. In fact, it forced the United States Supreme Court to finally what we call nationalize the Second Amendment. So in the spring of 2008, the Supreme Court of the United States held in the case of Heller v. the District of Columbia that the Second Amendment to the United States Constitution protects an individual's right to possess a firearm for private use and for cases of self-defense. However, the court itself narrowly focused the decision to only be applied to Washington, D.C. and any other federal enclaves, and did not and could not be carried out anywhere else. They purposely very, very narrowly focused the decision on just a couple of areas of the United States, and what we call by federal enclaves, or anything that's like Washington, D.C., so any other federal installations. But McDonald, up there in the left-hand picture, Otis McDonald, Chicago had passed kind of a draconian gun control law, and McDonald sued. You can see here McDonald v. the City of Chicago in 2010, and just 2 years later, the Supreme Court had to rule again on whether the Second Amendment applied to individuals at this time the state level. Remember, the first one's Washington, D.C. and any federal. So what they did was they selectively incorporated the original decision. Heller is selective in that manner. McDonald nationalized the Second Amendment. The city itself had argued that gun regulations were necessary to prevent more violence in the city, and all gun laws, such as their ban on handguns for private use, should be left to the states, not to the federal government. The Supreme Court disagreed in this case, and they said that in a 5-4 vote, that the city of Chicago could not ban guns in the manner that they had. And basically what the Supreme Court said for the first time was that people have the right to carry a concealed weapon with a permit or have one in their private home. And they also said, and this is Samuel Alito, one of the conservative justices, that this has to do with whether the freedom applies to every American in every city and town all over our country. Self-defense is a basic right, and the need for defense of self, family, and property is most acute in the home. This right applies to handguns because they are the most preferred firearm in the nation to keep and use for protection of one's home and family. Of course, liberals didn't agree with that. They were the 4 members of the court who voted against the right to bear arms. Now, the Third Amendment is something that we hardly ever worry about. This was actually something that did occur prior to the Revolutionary War. It prohibits the government from quartering troops forcibly in people's homes, with the exception of wartime. And this was something that, again, has not been an issue, but certainly was an issue like you see in 1765. The Fourth Amendment, which is what we're going to be looking at heavily when we get to civil rights and civil liberties. The Fourth Amendment is about searches and seizures. And this amendment guarantees that searches and seizures will be conducted only when a judge feels that there is a reasonable cause to issue a search warrant. And what that means is that law enforcement cannot go on a fishing expedition. They have to have what's called, again, reasonable cause. So you have to present evidence in some way that you think this is that this is happening, this is what you've seen, this is what has been observed. There has to be a preponderance, I think, of evidence, perhaps usable evidence by the state before a magistrate issues a search warrant. It also protects the right to privacy by limiting searches. So this is the other part of right to privacy. And when I talked about privacy, it's what you view, what you read, things in your home in the First Amendment. But here, the right to privacy is limited. It limits the type of searches that can occur. So again, something, as we perhaps have mentioned before, something has to be in plain sight for a warrant to not be needed, or there has to be another look at this would be where a crime is being committed at that time, and you can't wait. Somebody will possibly be hurt. There is no warrant needed there. Evidence seized illegally without a warrant cannot be used in court. We call that the fruit of the poisonous tree. And again, one of the things that occurs here is that it's up to the state to prove guilt. It's not up to the defendant to prove innocence. And the Fourth Amendment certainly illustrates that. The exclusionary and the plain view rule. As I kind of mentioned a minute ago, if something is in plain sight, it is admissible. But the exclusionary rule prevents prosecutions or prosecutors from using evidence acquired through unreasonable search and seizure, unless the officer sees that evidence in good faith. In Matt v. Ohio in 1961, it extended the exclusionary rule to the state as well as the federal cases, so we call that selective incorporation. Exigent circumstances allow officers to seize evidence without warrants if they believe that evidence can be destroyed by the suspect. So let's say that they find a defendant trying to dump cocaine down the toilet, and they manage to get some of it before he or she flushes it. And that is also part of the plain view rule that states that if the evidence is in plain view, it is admissible to confiscate. So there are some questions that we'll answer later on. Do search and seizure include this sneak and peek, which is what we call sometimes the things that occur on closed circuit television or CCTV, roving wiretaps, where again wiretaps are not on all the time, but you may be part of a group of people in which the government listens to your phone calls, reads your emails, things like that. They don't do it consistently, but they do it when the spirit moves in. Does this limit or protect your freedoms? I think it obviously limits your freedoms. On the other hand, it may increase your safety. And I simply don't know what the Founding Fathers would think. I think this is something that would probably confound them, because it's so new and it's so different, and it's probably most likely something that they never even thought of. Who can blame them? Who would have thought of electronic cameras in 1787? Now, another thing that occurs is a Miranda warning. This comes from Miranda v. Arizona. Do police officers always have to read these rights? Yes. Does this limit or protect your rights? It protects your rights, because anything you do say can be used against you in a court of law. So they also have to quit questioning you when you request a lawyer. But the officers carry these cards, and at some point you know it by heart. This is kind of a joke. Student, principal, I plead the Fifth, and if it helps, the Sixth and Seventh too. The Fifth Amendment states the student does not have to do what? And of course the answer to that is self-incrimination. So the Fifth and the Fourth are somewhat related. The Miranda warning says you have the right to remain silent, and that is certainly connected to the Fifth Amendment, the rights of an accused person. This amendment guarantees that no one can be tried for a serious crime unless a grand jury has decided there is enough evidence. And a person cannot be tried for the same crime twice, double jeopardy, and is guaranteed due process of law at the federal level. You cannot be forced to testify against yourself or answer questions that may incriminate you. and you have the right to remain silent. And I think I said here, I didn't here. I'm not sure if I said Fourth Amendment. I thought I was talking about the Fifth, but I'm a little tired tonight, so this is, of course, the Miranda's Fifth. Now, the Sixth Amendment is the right to a speedy trial. This amendment protects the rights of individuals charged with federal crimes to defend themselves in court. Now, a Sixth Amendment required a jury of 12 in federal cases. Can be fewer in state cases. Conviction does not require a unanimous vote like it does in state cases for murder and things like that. Now, I also want you to go back over here to the right. This amendment protects the rights of individuals charged with federal crimes to defend themselves in a court trial. The right to a speedy trial does not allow the government then to put you behind bars for a length of time to be determined by the government. This was actually a thing that was, the Sixth Amendment was used by O.J. Simpson to speed up his trial in 1994 when the prosecution wasn't ready. So you have the right to have a trial, a speedy trial by an impartial jury. You may be tried, you may ask to be tried by a judge. You may ask for a change of venue, but that's really, really difficult. Your crime perhaps needs to be so heinous that the consideration is you can't get a fair trial, and a venue is needed because at the place you're at now, everybody has heard about the case, and probably most people have made an opinion. Legal counsel must be provided for a defendant in federal and state courts. That comes from Gideon v. Wainwright in 1964 or 66. And to this day, that is a true statement. If you cannot afford a defense attorney, the state provides you a public defender. Most public defenders, of course, will urge you to take the deal. It's very you can get a trial, but you know the odds of you finding yourself exonerated by the jury is pretty low. Now here we have in 63, Gideon Wainwright did not receive an attorney, and he was railroaded into jail. He sat down in the law library of the Florida State Prison he was in and handwrote his petition to the Supreme Court, which accepted it, and history was made from there. Now, that lying individual, Casey Anthony, accused of and acquitted for killing her daughter, and Jackie Burkle, accused of killing newborn twins, the venues were not changed. At least in Casey Anthony's case, it was still held in Orlando. She was from a small town outside Orlando, but it was broadcast nationwide on all the major news networks. I think that was almost the last trial in which that happened. Both of them were, well, at least Casey Anthony was acquitted, and she's no longer a household name. Should the white officer who killed Michael Brown in Ferguson, Missouri, ask for a change of venue if he was charged with a crime? If he had been charged with a crime, I guess I should have changed this. Again, I didn't make it up, but obviously the Justice Department did not find enough grounds to charge. If he had, the city of Ferguson is 52% black. Could he have gotten a fair trial? Maybe, maybe not. Don't know. But if you present a strong enough case, your venue can be changed. The Seventh Amendment, civil suits. You have the right to a jury trial in federal court to settle disputes over property. However, a judge may also decide. Magistrate courts settle suits under $3,000. District courts settle larger amounts, and federal courts handle big cases. The Eighth Amendment, bail and punishment. This amendment prohibits excessive bail, prohibits excessive fines, and bans cruel and unusual punishment. The predominant case here is Gregg v. Georgia. Um, a couple of things that have happened. Firing squad, is it cruel and unusual? Utah was the last state to use that. Is it a benefit or a risk to our freedoms to put someone to death? So is the state putting someone to death a benefit or a risk to our freedoms? You'll get passionate views from both sides. So in Gregg v. Georgia in 1976, the Supreme Court confirmed that the death penalty does not violate the Bill of Rights, and therefore it is not considered cruel and unusual. In Miller v. Alabama in 2010, the court said you can't give juveniles under 15 years old life without parole for heinous crimes. Also, a case out of Virginia from a court decision said you cannot put mentally handicapped people to death either, because they're not under control. And this involved a case where an 18-year-old with the mind of a 5-year-old had killed an elderly woman, didn't know his own strength, but he was mentally challenged and therefore could not be put to death by the state. The Ninth Amendment, power is reserved to the people. This amendment provides that the people's rights are not limited to those spelled out in the Constitution. All other rights not spelled out in the Constitution are retained by the people. Problematic for the government. The Tenth Amendment, power is reserved to the states. Power is not given to the national government by the Constitution, belong to the states or to the people. This amendment protects the people and states from an all-powerful federal government. So you know that the first 10 amendments are called the Bill of Rights. Do they protect our rights or limit our rights? Are they a benefit or a risk? I think the pile of rocks falls both ways on both counts. So remember the 10th Amendment. States have rights too, except when the federal government says they don't. The 11th Amendment, suits against states. This amendment prohibits a state from being sued in federal court by citizens of another state or another nation. Has to go to nowadays to a special court. The 12th Amendment, the election of the president and vice president. The Electoral College must use separate ballots in voting for the president and vice president. Remember the elections of 1800. The election of 1804 went to the House of Representatives, as did the election of 1824. The 13th, 14th, and 15th Amendments are also referred to as the Civil War Amendments. The 13th Amendment abolished slavery. But I want you to see what's in blue down there. The Supreme Court has held that the draft is not in violation of this amendment. Many people feel that being put involuntarily into the armed forces is a form of slavery. All the government wants to do is to know how many people are available in case of war, but people will stretch this. The 14th Amendment in 1868, this is huge because this is the amendment that comes up so often nowadays. The rights of citizens. This amendment is intended to protect the legal rights of freed slaves and their descendants and to penalize the southern states for the war. It prohibits a state from depriving any person of life, liberty, or property without due process of law and guarantees equal protection of the law in all states. Unfortunately, that did not become true generally until the 1950s, 1960s. The 15th Amendment, 1870, the right to vote. This amendment prohibits the government from denying a person's right to vote on the basis of race. States got around this amendment by implementing poll taxes and literacy tests and grandfather clause and white primary, and of course women didn't get the right to vote until 1920. So there were so many things wrong with the outcome of the 15th Amendment until those got resolved by other amendments, other laws. The 14th Amendment is like our second Bill of Rights. The first 10 protect us from abuses from the central government. The 14th protects us from the abuses from the states. And it has 4 clauses: citizenship, privileges and immunities, due process, and equal protection of the laws. And it is the basis for so many decisions made by the courts, federal courts and the state courts nowadays, but in particular the federal courts. So let's take a look at the 14th Amendment. Now we're going to look at this again when we get to the Supreme Court. But Section 1 says all persons born or naturalized in the United States and subject to the jurisdiction, not owing allegiance to another country thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protection of the laws. Those things in blue are what's so important and what is a kind of wording that is not simplistic, but it is simple and it's very understandable. And we apply it differently nowadays than we did post-Civil War. Thank goodness. So this begs the question, how do people use the Constitution for contentious issues, especially the 14th Amendment? Well, heck, gay marriage was used. The 14th Amendment was used to make a statement that the states were discriminating against people who wanted to have same-sex marriages. And that was a violation of the Equal Protection Clause. You were teaching or treating people differently. And I'm sure the court had a more convoluted and more correct and more distinct answer. But basically, these contentious issues have really focused on both the due process and, in particular, equal protection. So due process is in the 5th, it's federal. In the 14th, it's state and individuals. And so there's two types. There's procedural due process. And in procedural due process, the government cannot use unfair procedures in fulfilling its responsibility. So police must use fair procedures in conducting investigations and in questioning and arresting such suspects. So they need to follow procedures. They need to share evidence with the defense, etc., etc. It can't be so lopsided that a defendant has no chance of being exonerated of a crime. Substantive due process says the government has no right to regulate personal privacy, such as what you believe, who your friends are, what kind of work you do, what tattoos you want, who you date, what kind of clothes you wear, where you visit, etc., etc., etc. We see much more about procedural than we do substantive. The 16th Amendment established the state income tax. The 17th Amendment, direct election of senators, that changes the original Constitution. The 18th Amendment, prohibition of alcoholic beverages, repealed by the 21st Amendment. The 19th Amendment, is, of course, is women's suffrage, a huge deal. The 20th Amendment is the lame duck amendment. This amendment sets new dates for Congress to begin its term and for the inauguration of the President and Vice President. Moved the inauguration from March 4th to January 20th. That was a modern riff on this. Remember that FDR sat in New York ready to take the presidency, take on the presidency, and had to wait and wait and wait. By the time he got on the train to go to Washington, the economy itself had just about slowed to a halt. So it was thought that in this modern day and age, when you didn't have to wait weeks for someone to arrive at inauguration, in this day of much faster transportation, we could move the date up than they have. The 21st Amendment is the repeal of prohibition. The 22nd Amendment is the limit on presidential terms. This was kind of a based on the fact that Roosevelt had been elected president 4 times. It limits the president to a maximum of 2 elected terms under special circumstances, up to 10 years, but normally 8 years. So President Bush, 8 years, President Obama, 8 years, President Clinton, 8 years. The 23rd Amendment gave not only the right to vote, but presidential electors for the District of Columbia for the first time. They still didn't have representation in Congress. They do now, and that is a voting rep. But at the time, in 1961, they didn't. And I don't know if they'll ever get senators or not, because unless Washington D.C. becomes more competitive politically, that's just not going to happen. The 24th Amendment is the abolition of the poll tax, whereas the other things have been taken care of through court cases and things. The poll tax was specifically designated as something that needed to be put into the Constitution. You did not pay to vote. The 25th Amendment, presidential disability and succession, established the process for the vice president to take over leadership of the nation when the president is disabled. The 26th Amendment gives 18-year-olds the vote. And the 27th Amendment is a restraint on congressional salaries. You cannot receive a raise the same year that you vote for it if you're a member of Congress. So, 40 slides. I try to run through the last ones. You know them, you've studied the Constitution. And now we're almost ready for debate.